Committee back into order. We do have a quorum, and we are back on to Senate File 970 as amended. I know there were a number of amendments that were proposed earlier today. So Senator Limmer has his hand up, so we'll go to Senator Limmer to begin with.
Thank you, Mr. Chairman. Just a brief announcement. I was reminded by the leadership corner that we have to be done with this bill tonight. And so I'm hoping that we can get through all of our discussions and amendments this evening, and we'll do our very best. So bring it on.
Thank you, Senator Limmer. Senator Bigham.
Thank you, Mr. Chair. I have the A3 amendment. Sorry, A3 amendment.
Senator Bigham moves the A3 amendment.
Okay.
Senator Bigham, to your amendment.
Thank you. What the A3 amendment does is addresses disparities in the cannabis world. This bill deals with the disparities between the flower weed mixture and the processed part of marijuana. So this actually goes back to the 70s. This is not the first time I brought this bill up, but it needs to be addressed. And so I'm hoping that this committee will help solve this disparity. This bill is actually a bipartisan bill through the years. Former Senator, GOP Senator Scott Jensen has carried this bill or has been an author on the bill. And then Senator Jim Abler, Republican out of Anoka, he is carrying the bill. And I brought this up at one of our last markups because I think we need to work at decriminalizing and making parity into our laws when it deals with cannabis. So basically the decriminalization laws that were written way back in 1976, they don't apply to any of the forms of processed cannabis, like the concentrates, the edibles, the wax, and it's problematic. And it's gone through the court system in, if you get caught with 1.5 ounces of bud or flower cannabis, you only get a petty misdemeanor. And now you're looking at wax that you're gonna, if you have the same amount, you're gonna be getting a felony. So we just have so much disparity in our laws. And there's just been a lot of comments in the public that we need to deal with this. The time is right to do this. There were, if you look at the arrests, felony level arrests in DPS, according to DPS, there's 78 felony arrests for cannabis in 2015. And that increased all the way up to 208 in 2019. And more importantly, what I think kind of draws my attention to this is our medical marijuana cannabis law. So, in 2014, we made a decision, not me, because I wasn't here, but members of this committee that were in the body at that time, the medical marijuana program, the cannabis program, believed that the use of flower cannabis was not as preferable to the uses of processed cannabis, but yet our decriminalization laws kind of send that opposite message. And I know we're trying to figure that other side out too, and hopefully we'll get that across the finish line. But the A3 amendment basically makes that parity through making sure that marijuana flowers, 8 grams or less of any non-flower marijuana mixture, and we're going through the amounts. We're decriminalizing the small amounts of it, and I hope that when we get to a conference committee, we can talk
all amounts of this 4 years ago.
We can we can talk about this as it goes through the process, but we can't have people being charged with crimes for small amounts of possession. I mean, that's what it comes down to. So I can entertain some questions, Mr. Chair, but I just wish the committee would take the time to discuss some of the equity issues that come with our cannabis laws. We've spent so much time on treatment and so much time on programming, and maybe if these low-level crimes were not crimes, we wouldn't, the criminal justice side of it would be more equitable. So that's it, Mr. Chair.
Thank you, Senator Bingham. Senator Limmer.
Thank you, Mr. Chair. The committee may have heard me ask a question. Didn't we lower the quantity amounts 3 or 4 years ago on things like marijuana? I thought we had done that a few years ago.
Yeah, but
Can anyone tell me, or maybe council could tell me?
yeah, Mr. Chair, we did, but it's not on processed stuff. It's on flour. So
I thought it was just on weight.
yeah, but on it didn't deal with the process side of it. So like wax or gummies or edibles.
All right. The question second, I wish we would have had the benefit of prosecutors and defense bar to give us added information when we're changing evidentiary standards. I think that's important to have. As I look over this, we get into drug paraphernalia, the permitted uses of marijuana. And I know that I'm not blind to the effect of a changing attitude in some circles in Minnesota. However, this seems like it's a pretty serious bill to consider at this late hour of the session.
Senator Bingham.
Mr. Chair, I have brought this forward before, and to say that this hasn't been introduced in past sessions would be not true. So we've had a lot of time through the sessions that you've been chair to deal with these issues in a bipartisan manner, because Republicans have been on this bill, and currently, again, the chief author of a provision is Senator Abler. So I do just, Mr. Chair, I just want to say that we can't not have the conversations about decriminalizing small amounts of marijuana. People should not have a criminal record for this. But more importantly, we are exactly doing for the medical marijuana program that we're trying to do with this. There we're saying process only, and process is the best, but no flour. And now we're saying flour and process are so unequal that people are getting charged with higher level of crime. So I just want to point out that this discussion has been obstructed for years, and it's time, Mr. Chair. And fine, it may not be time at 5:45 on the day of deadline. I get that. And there is no fiscal note on it, so I understand that. And both of my other really good amendments that I still argue would have put you in a better spot in conference committee, because you could have blamed me for adding them. But I'm not in charge. I don't want to have a negative vote on this because I think this is a tried and true policy discussion that this committee has failed to have. So I will withdraw the A3 amendment.
Senator Bingham withdraws the A3 amendment.
And then
On to Senate File 970 as amended.
Yeah, Mr. Chair.
Further discussion.
Yeah, Mr. Chair, the A7 amendment that I'd like to offer.
Senator Bingham, you offer the A7 amendment?
Yes. And Mr. Chair,
Senator Bingham, to the A7 amendment.
Mr. Chair, this does have a fiscal impact, and it comes out of the corrections department. This is Senator Duckworth's bill that we had just an amazing hearing on. We heard from some incredible survivors, Mr. Chair, and I want to point out how I think moved the whole committee was on the ability to fix a situation dealing with the fact that the National Guard does not have an active investigative component, which is unlike the active military branches. So they have to use the local law enforcement. And there's some disparities there. And you know what? Senator Duckworth saw that and really worked at trying to bring some justice there. And we had a really good committee hearing, and I appreciate the engagement of Senator Kiffmeyer in that questioning. I mean, there were some really good discussions brought up, and I think that this is a worthy program that we need to advance. And so I'm hoping, I don't need to spend a lot of time on it because it received a very thorough hearing. And so I'm hoping that we can have this added to the omnibus bill so that, again, we can have a discussion in conference committee and really bring justice to these survivors. I just was really moved by that committee, and especially the conversations we had yesterday too about, bringing justice and making sure that we're not having repeat offenses and creating more victims. So I would stand for any questions, but again, this is the same bill that Senator Duckworth brought forward.
Thank you, Senator Bingham. Senator Limmer.
Thank you, Mr. Chair. Senator Bingham, I'm assuming that the funding source is raiding the DOC money again.
Mr. Chair.
Senator Bingham.
Yeah, Mr. Chair, correct.
Okay.
Senator Limmer.
This one doesn't bother me as much, and I'll tell you why. The unit that we're talking about on line 1.13, the unit for this investigative unit they're talking about is going to expire in just a few short years.
Yeah.
And so the money that we are involving ourselves in is, at least for our purposes, short-lived. I just want to make sure that we realize what we're doing. We continue to pull money out of the DOC budget. Sometime soon, I hope, the courts will go back into action and they'll start considering criminal cases, and out of those criminal cases, people will go to prison. And that will trigger back the DOC budget into covering those new cases. So we can only go so far. But nevertheless, Senator Bingham, you have convinced me. I think this is worthwhile to include in the bill. So I think it's necessary to have that collaboration between National Guard and the BCA. So, well,
thank you, Mr. Chair.
I would urge the committee to support it.
Thank you, Mr. Chair. And what I would say is that we know that, as Senator Pappas pointed out.
Mr. Chair.
Senator Kiffmeyer.
Thank you for recognizing me. I think it's so easy to become familiar here, to forget that we need to be recognized by the chair before we speak.
Oh, Senator Kiffmeyer, you're on mute.
So, Mr. Chair, what I was saying is that I think if you would please remind all of us to wait for you to recognize before we speak, because people listen to the audio record. We can see each other, we're talking, but that is not the case when somebody only has audio. So if we let the chair recognize, then it helps have order and also helps people who only have audio. Thank you.
Thank you, Senator Kiffmeyer. Senator Bingham.
Thank you, Mr. Chair. Senator Limmer, I appreciate that and appreciate your support for the amendment. And I do know that in conference committee, this will all get sorted out, as Senator Pappas and Senator Latz on previous amendments have pointed out. So I appreciate that, and I urge support of the A7, right?
Correct.
A7 amendment. Thank you.
I just have one quick question. We've been talking a lot about the DOC and their budget. Has anybody talked to the DOC about going into their budget and taking funds? Senator Limmer?
Thank you, Mr. Chairman. Yes, I just spoke during our recent break with the commissioner, and he is concerned that, and I told him, whenever you have an open budget like that with savings, it attracts legislators really fast. And so I told him that I'm trying to make sure that our committee realizes what's happening. I think he's putting hope in the fact that there might be a little more money floating around as we get toward the end of the session. But nevertheless, I don't know where the guarantee is in that, but maybe just past tradition. But nevertheless, I'm concerned because I don't have a crystal ball. And I really don't want myself or any other chairman of this committee to deal with a deficiency when the prisons start filling up again, and then it becomes an urgent matter. This should be something that we have ongoing commitment to cover, especially in the areas of essential services like that. The other thing is, I'm concerned that this, if it went to that point, we would be taking the money from prison guard salaries. And I don't think they deserve that either. So just concern. I've been talking about it a lot today, but that's my concern again.
Thank you, Senator Limmer. Appreciate that. So we're back on the motion to adopt the A7 Bingham Amendment. We could have microphones on and video camera on if possible. I know Senator Anderson is having some technical difficulties, so he's joining us by phone, if you can see that. So all in favor of the A7 amendment, please indicate by saying aye.
Aye.
All opposed? Motion prevails. The A7 amendment is adopted. So we are on the SF 970 as amended. Any further comments or amendments?
Mr. Chairman.
Senator Latz.
Thank you, Mr. Chairman. I have the A14 amendment, please.
Senator Latz moves the A14 amendment. Senator Latz to the amendment.
I'm going to pull it up here, Mr. Chairman. Mr. Chairman, the A14 amendment gives prosecutors the authority and the discretion to initiate in court a review of a sentence for already convicted individuals when in the prosecutors, and this would really apply to county attorneys who handle the felony level offenses that end up in state prisons, when in their judgment they think that after a certain number of years that an offender has demonstrated significant rehabilitation and or that their sentence at the time of sentencing in retrospect appears to have been over sentenced or sentenced to longer terms in prison than the prosecutor now thinks is appropriate. This provides for basically a cause of action or a legal proceeding by which the prosecutor may file a petition in court and initiate that sentencing review. It sets forth the requirements in the petition. which includes the details of the underlying offense, the names and identification information for any victims that would want to have input in the process, steps the individual in prison has taken towards a personal rehabilitation, such as treatment, work, good conduct, or other personal history, their prior criminal record and charges, and other relevant information. Sets forth the proceedings for hearings, service of the petition, the kind of remedies that would be available to adjust the person, the individual's sentence, the criteria that the court should apply in making that determination, including things such as what impact that adjustment would have on public safety, whether it would promote rehabilitation, whether it would properly reflect the severity of the underlying offense, or reduce sentencing disparities, which is something that we have paid close attention to in this committee, both the proportionality among different kinds of offenses and the disparities for similarly situated offenders, but who may have received substantially different prison sentences because of the particular judge or the particular area of the state in which they committed an offense. It sets forth all of the background information that should be considered, including the individual's performance. And by the way, this would also apply to lengths of probation. So people who may be out of prison and who are on probation, but maybe the county attorney's office thinks maybe 20 years of probation is no longer appropriate. They can be released after 10 years of probation, for example. So you would look at how they performed while on probation, look at rehabilitation efforts that they have made or may continue to be making in the community, whether remorse, age, diminished physical condition, or other factors have reduced the likelihood of future offenses being committed by that individual, the amount of time they've already served in custody or under supervision, and significant changes in law or sentencing practice since the date of offense. We make adjustments every year in this committee and in state law, and someone who was sentenced 20 years ago to an offense may not be able to take advantage of new sentences, where someone who committed the same type of offense today might receive a shorter sentence under current statute than a person who committed the same offense 20 years ago received under then current statute. This provides a mechanism by which a court could review those circumstances. There is a mechanism also available. They can look at what restitution has been involved and would give an opportunity to reduce or eliminate court-ordered restitution under appropriate circumstances, and reduce or eliminate a term of the conditional release when a person has been committed to the Commissioner of Corrections. So maybe a particular term of that conditional release is no longer relevant or helpful or necessary, and that could also be adjusted. In short, it gives an opportunity for a judge on the discretionary request of a county attorney to review an old sentence and see if it's appropriate to make adjustments in that sentence now, where ordinarily there is no mechanism for a judge to look back or for a county attorney to say, hey, there should be another look at this. Maybe someone's doing really well and we don't need to continue to incarcerate them or maintain the intense level of supervision, or we don't need to keep them on probation for another 10 years, or whatever the circumstances are. There isn't any formal mechanism now, and there at least ought to be a mechanism to facilitate this review. And it also provides a mechanism for appeal in case there is a desire to do that. Mr. Chairman, I asked that this be available as a tool and ask for your support on this particular A14 amendment.
Thank you, Senator Latz. Senator Limmer.
Thank you, Mr. Chair. I suppose you can imagine what I'm going to say, but I do have a couple questions on this. It's kind of intriguing, but this idea, when I first scanned through the amendment, I didn't quite understand where it was going. Thank you for the description, Senator Latz. In some ways, it almost looks like a mini modified version of indeterminate sentencing, where a sentence can be reduced, modified, based on the promotion of a prosecutor. I'm not quite sure where the prosecutor would get all this information. Having worked in a correction system myself, I saw a lot of behavior of inmates that a prosecutor would probably just, roll his eyes over. And then when someone like a probation officer would come and get involved in, this is especially regarding inmates that were on their way out, but they were greeted by a probation officer in preparation for their release. The inmates were on their best behavior. And so trying to determine the behavior of an inmate or their progress, I'm not sure is always clear to a prosecutor. I suppose there's others that he or she would rely on. It almost looks like a modified parole board in one person. And then having the Commissioner of Corrections may request that a prosecutor review a case. And I'm also wondering, is this also considered classification of any criminal violation? Or is it limited to low-level crimes? A lot of questions, Senator Latz.
Senator Latz, would you like to address Senator Limmer's concerns?
Yes, thank you, Mr. Chairman and Senator Limmer. All good questions. Whether or not, the first question having to do with whether this seems like a mini version of an indeterminate sentencing scheme. My recollection of the proposals along those lines do not have the review of the sentence in an indeterminate sentence go back to the sentencing judge. They are reviewed by other administrative officials or a mini parole board, indeterminate sentencing review board or something like that. So this scheme would go back into court. So there's a substantial difference there. It would also, because you've got the provision of the county attorney's involvement in deciding whether or not to seek the review. It's not every sentence is going to come up for review under some kind of an indeterminate sentencing scheme. There's not going to be an automatic process for review after a certain period of time or anything like that. It'll be completely within the discretion of the county attorneys, and the county attorneys or the prosecutors, I expect will use it in probably comparatively few cases. But in those cases where they think there's an outlier or they think someone's made substantial progress that maybe wasn't anticipated in the course of the original sentence, they'd have the tool available in their toolbox to try to maybe right size the justice in that particular case, what would be considered to be justice in the particular case, to reflect current circumstances and not only be bound by a sentencing judge's inevitably imperfect view of what might happen in the future with regard to a particular individual who's being sentenced. As part of judges' sentencing, they make decisions. Do I think you're going to, when they're looking at a defendant, part of their criteria is whether or not they think a person has a reasonable chance of rehabilitation. Do they need to be in prison? Could they be on, in the workhouse with a shorter prison term? Do they need to be in prison for 30 years as opposed to 15 years or 20 years? because they think a person is indelibly or innately, violent or harmful or is never going to be able to rehabilitate, whereas others they think might be. But they can't foresee the future perfectly. No one can. And the judges will make their absolute best judgments at the time of sentencing, but they'll be the first to admit that they can't predict exactly how a particular person is going to respond to all of the opportunities that are available within the prison system to rehabilitate, whether it's treatment, whether it's getting a GED, whether it's learning a workforce skill, whether they seek spiritual sustenance, whether they get along well with other people or whether they cause trouble with other people. So that's what this tool would be available to, is to be able to take that projected future and take a look at it and see what actually materialized. And if it wasn't exactly as a judge predicted and someone's doing much, much better, it gives a chance, an opportunity for a prosecutor to look at it and say, well, in light of what we know now, maybe it's more just, more fair to seek an adjustment on the sentence. With regard to your concern about sources of information, of course, very few people are actually in the prisons observing individual prisoner behavior. On the other hand, prisons, corrections officials do keep records of infractions, and they would have an opportunity to provide information in the process. Someone who isn't constantly getting in trouble, isn't losing good time, but instead is participating in programming, and if there's a record of attendance in the programming and so on, that information is available. We don't have any kind of a electronic data creator that attaches to every prisoner's wrist, that identifies when they have,
Yet.
not yet, when they get overly emotional or when they get a little edgy and snap at another prisoner, or when, the food is so terrible that day they didn't eat much and
Too much pepper in the eggs. Yeah.
Right. Or, maybe they had a cellmate when they were double bunked who wasn't sleeping well or was acting out, and, they don't sleep well as a result, or they get into a conflict with a problematic cellmate and it goes onto their record. I mean, you can't keep, absolute every minute by minute monitoring, but I mean, you probably know better than most. There is a data monitoring system. There's a certain amount of data. In fact, I think our correctional system, from what I understand, has more data than most systems have to enable decisions to be at least as informed as possible. And that, with regard to a parole board, I guess that kind of ties into the question of indeterminate sentencing. I mean, this is not a formal parole board. And of course, a parole board doesn't necessarily look at, all of these options for resolution. But I support the concept of a parole board too, for the same underlying reasons. But this is a different kind of mechanism. And again, that's a separate board that would look at it. Here it would go back to the judge in the county where the original sentence occurred. I would anticipate if it's the original sentencing judge, it might end up back in front of that judge. If not, after a period of time, judges come and go, of course, they retire. So there are other opportunities for review of a sentence as well. And then your last question was with regard to the type of violation. I don't think there's anything in this amendment that is specific or exempts certain types of violations or convictions, offenses from this review. Certainly there'll be certain kinds of offenses which are much less likely to have a county attorney decide that they want review. And similarly, they're much less likely to result in any kind of adjustment if it were to get into the court on such a petition. But there are people who do some pretty bad things when they're 18 or 21 years old, and by the time they're 45, maybe they've changed. We know from science that the impulse control in the human brain isn't even fully developed until age 25. Yet we've got people in their late teens and early 20s who are sentenced to 20 years in prison for things that they did. And, they physiologically have changed by the time they get pretty far into their sentence. And one might reasonably argue that it's not fair to preclude them from having an opportunity for review under these circumstances.
Senator Latz, is this idea used in any other state?
I don't know the specific answer to that question, and I don't know if anyone in the Senate Counsel's office knows. Anyone who's listening who has an answer to that question can go ahead and text me. No, I don't know the answer to that question. I do know that there are county attorneys that are very interested in doing this. For example, in Ramsey County, I know that the county attorney there, John Choi, is setting up a committee to take a look at situations that might warrant this kind of a review. But I don't know what other states are doing in this regard.
Senator Latz. Senator Limmer, you have a follow-up?
Just a quick question, or not a question, comment. Senator
I'm sorry,
Latz,
Mr. Chairman, I have an answer now. To your question, I just got it.
Senator Latz.
I called for help from a friend, and I got one from our career prosecutor, appellate criminal prosecutor in Hennepin County, and State Rep Kelly Moeller, who tells me that California has a mechanism set up to do this. And it, in her contribution to this conversation, that it's actually encouraged prisoners to engage in programming because it gives them hope that they'll get the benefit of that programming, perhaps by some accommodation in their sentence.
now, Senator Latz, Mr. Chairman, now, Senator Latz, this is the second time a member of the other body has been relied on as a resource for our debate. I've never heard you rely on those people before.
Mr. Chairman, I seek expertise where I find it, and we are very fortunate to have members of the other body that have some extensive expertise to share.
You are a better politician than I am, Senator Latz.
And I understand it's been very carefully used even in California. There hasn't been a flood into the courts.
Senator Latz, you know that I tried to set up policies around the formation of this bill to be focused on budget. And this is a very interesting idea, but it is policy only. And for that reason, I'm sorry, but I'd have to be opposed to your amendment at this time. It is an intriguing idea, though.
So, Mr. Chairman, if I may, and with all due respect, because I know, as I said yesterday, the challenges of managing a committee. But this year, there have been a lot of committees that have heard a fair amount of policy. This committee has heard comparatively few policy bills. And I've made this point in the past, but we, in my judgment, have not utilized all of the resources or time available to this committee to hear policy bills. And of the policy bills that were heard, which I would say be comparatively few, a very small proportion of those were DFL authored policy bills. Unfortunately, it seems that our side of the aisle has been left with very few options to have our initiatives heard. We did try in the run-up to first and second deadline to add some pure policy bills to what we're turning into some broader or omnibus policy-oriented bills. Some amendments which were absolutely non-controversial, that had broad bipartisan, bicameral, stakeholder consensus, and ones that we couldn't even get hearings on, some of which have been around the legislature for a few years, just waiting to be passed because they were good law, and some of which the chairman even has agreed to, some of which have been authored by For example, Senator Johnson. And yet, we couldn't get hearings on them in this committee during the regular portion of the session, and we couldn't even get concurrence to add them to omnibus policy bills. And now, having been denied those opportunities to move bills forward, we're being told we can't add them here because we never had policy hearings on them and there's no money involved. So it seems that at least our side of the aisle has been stymied at every turn, even with interesting, consensus-oriented, productive policy proposals. And that's why you're seeing the frustration among our members who are trying to bring things forward now, because we haven't been able to bring them forward before. I've had bills we've made 2 or 3 requests for hearings, Mr. Chairman, that I know you support on the merits, and that would, or that I firmly believe you would fully support and would generate support from the committee, were we given the opportunity to bring in the stakeholders, to bring in the testifiers, to bring in the experts, to have a hearing on them. But we have not been given the opportunity to do that. So we are left with this last minute attempt to get even our policy bills onto some piece of legislation that's going to move out of the Senate committee. So with all due respect, I would ask the chairman to allow this policy bill to go forward. We know we're going to be seeing a lot of policy only in conference committee. It gets a little bit old, frankly. If we don't give a path for policy out of the committee that's in a non-budget pathway, and then to deny the budget pathway as well, it ends up just being a blockade, which I don't think is a good approach to considering policy, let alone passing good government legislation. So I would ask that the chairman, in your discretion, consider allowing this initiative to move on to this bill.
Thank you, Senator Latz. Just briefly here, we are on Senate File 970 as amended, and this is the A14 amendment. Senator Limmer.
Well, Mr. Chair, I've been told that this particular amendment was in the form of a bill. It was previously Senator Pappas's bill. Senator Latz, I believe you took it over as chief author. But what I can see is it was introduced one day before the first deadline. And so, bringing an idea like this into discussion and hope for passage during deadline week, I'm just, and then at the same time, I know you can appreciate that our staff was lining up bills weeks ahead of time. We usually have about a 2-week lead. So I'm part of this is of the idea that this is kind of rushing it a little bit, don't you think, by pushing it into deadline weeks and then not having an opportunity to really consider where it was for a hearing. So that's kind of where we're at.
So, Mr. Chairman,
Senator Latz.
First of all, I'll just state, and I appreciate Senator Pappas's help because she's been physically present at the Capitol, and I have not been. So just as a matter of process, she's been willing to sign jackets to get them introduced, and then we can electronically bring motions to switch chief authors. And I appreciate the help of her and Senator Bigham as well in doing those things. Secondly, as I have indicated before, even in those deadline weeks, we were giving, the committee, I should say, was giving informational hearings to bills that were taking up multiple hours. We're hearing bills that didn't even, Republican bills that didn't even have House companions. We left unused the equivalent of about over 6 weeks worth of regular Judiciary Committee hearing time. The hours that were available to us, just that were used on the Tuesdays and Thursdays of deadline weeks, and on the Fridays when the deadline was midnight and we adjourned at noon or 1 or adjourned at 4 o'clock. So there were many, many hours that were available to this committee. And this is in the past, certainly when I was chair of the committee, we would have evening hearings throughout the legislative session because there were so many initiatives that came through Judiciary. We wanted to give opportunities for ideas to be vetted. And you know that it was not infrequent that we would listen to ideas, proposals by legislators on both sides of the aisle, and we would determine as a committee that maybe it wasn't ready to be advanced. To the great frustration, I know, of many of our colleagues. But we gave them an opportunity to make their presentation and to have the stakeholders contribute to the conversation. Then we used our judgment as, to decide whether we thought it merited moving forward. But we can't even apply that judgment if we don't give an opportunity for the hearing. We left a lot of time on the floor that went unused. So I think it's a little bit difficult to comprehend now the explanation that we simply didn't have time, because we did. We simply failed to use it. And we could have had time. We had time to hear this, even given the date it was introduced. And we made our requests for hearings, but it wasn't scheduled. And in my judgment, it should have been. It was a worthy proposal that should have received a good vetting. And the problem, part of the problem is that, we've got stuff backed up from several years now that weren't given hearings and weren't advanced. And so part of the backlog in this committee is one of the committee's own making. And not just the fact that there are lots of bills get introduced that have our jurisdiction, but lots of bills that get introduced that are really significant and valuable proposals that deserve the time and the energy and the public vetting to be considered, and they haven't been getting hearings. So now there's a backlog more than usual that I think we need to remedy. And I'm trying to remedy it in a small way by bringing this as an amendment, because I couldn't get a hearing on the merits when we had time to give it a hearing on the merits.
Mr. Chairman.
Thank you, Senator Matt. Senator Limmer.
The only thing I can say is one man's agenda is one man's backlog, is another man's backlog. Some of the ideas philosophically don't always match the other party in power, and other times they do. I think there's interest in these kind of creative ideas, but considering it a backlog versus an agenda, I think we have to keep in mind. And so I'll leave it at that, but nevertheless, I don't think we're prepared to bring this up at this time. I haven't heard what county attorneys have said about it. Haven't heard what the judicial system has said about it. I think they're all participants in the criminal justice system. And I just think that we need to have a wider discussion. And I don't think we're going to get that tonight. So that's where we're at.
Thank you, Senator Limmer.
Mr. Chairman, I'd like to ask when we can have that wider discussion.
Senator Limmer.
It won't be today.
Thank you, Senator Limmer. Senator Bingham.
Thank you, Mr. Chair. Senator Limmer, one of the first times I met you was in a conference committee, and I was sitting right next to then Chair Deb Hillstrom, and we collectively between the House and the Senate always had a strict policy bill, omnibus bill, and a strict finance bill. And I think that not having those has really made both institutions step backwards. We need to get back to that, and we need to get back to the good old days. And I tell you what, when Senator Johnson and I are in charge someday, we're going to do that, and we're going to do what any good chair does, only put our own bills in there. And we need to get back to respecting what you're trying to do, Mr. Chair, of no policy, only finance, but then you've got to give an opportunity for policy. I mean, I think that's all that people are asking. We could have had a data privacy omnibus bill. We used to do that all the time. Half the floor was asleep, except for, you know, Tom Emmer and Steve Simon, but that's besides the point. We still had a policy discussion about it. We had policy omnibus bills that then matched up with finance bills later on in the week. It just takes a little planning and a little cooperation. And I don't know where that happened. And that's one of the greatest differences that I've seen coming back here after my break from between the House and the Senate with a stop on the county board. So we need to get back to that. There's nothing wrong with that. There's nothing wrong with sitting down and having the discussion on a strictly policy bill, as 3 amendments now are going to be rejected, 4, sorry, that are strictly policy, that really deserve that vetting. So I don't understand why we couldn't have had a policy only omnibus bill and then your finance bill. All the technical department stuff went into the policy bill, and anything controversial from the departments had to go as a standalone. So, I mean, I guess maybe it's a walk down memory lane and nostalgia, but I remember conference committees that it was you, Chair Limmer, Senator Latz, Senator Mimua, Senator Higgins, and one other person I can't remember. And my job was to watch Senator Higgins' reaction when we did the side-by-side, because I could react how the Senate conferees were going to go by her reaction, and I noted that, and it helped the House. So if she's watching, she knows her secret now. So those are the days that I think we got progress done, Mr. Chair.
All right. Thank you very much. With that, members, we will move to take up the motion, the A14, Senator Latz's motion to pass the A14.
Mr.
Members,
Chairman,
Senator Latz.
I'm going to withdraw the A14 amendment.
Thank you, Senator Latz. The A14 amendment has been withdrawn. Back to Senate File 970 as amended. Senator Latz.
Mr. Chairman, I'd like the committee to consider the A9 amendment.
Senator Latz moves the A9 amendment. Senator Latz, to your amendment.
Thank you, Mr. Chairman. I'm going to make sure I bring up the amendment myself here as well. This is an amendment which I think the committee may recognize. I believe the Chairman Limmer will recognize, and I think based on our past mutuality on issues of fines and fees and surcharges, and believing that they are too high, I guess it's a way to put it, is we might find some agreement on this. The A9 amendment that I want to put before the committee, I want to first indicate that I do not want Section 8 of the amendment to be included. So in the way that we did before, I'll just ask the committee to consider the A9 amendment through line 2.31 as Section 8 starts on page 3, it's just the third page to the end. I do not wish that to be considered. What the amendment basically does is it gives the court the discretion when sentencing a defendant to waive the currently mandatory $75 surcharge on criminal convictions. This particular surcharge, which applies to traffic violations as well as other criminal convictions, was imposed quite a few years ago when we had a budget shortfall, frankly, and it was viewed as kind of a user fee. or as a way to bring in revenue to the budget. But my understanding, and I think Mr. Turner could probably confirm this, is that the revenue from this surcharge does not go into the operation of the courts or the judiciary as a whole or Department of Public Safety, but it goes into the general fund. I see Mr. Turner is nodding his head. So essentially what this was a tax on those who go through the judicial system, but a tax that was targeted on that particular subgroup of people to help fund for all the general services of the legislature. There are quite frequently people who come through who are represented by public defenders, who are pro se without an attorney because either they chose not to hire one or because they didn't qualify for the public defender, but still were suffering financial hardships. And for whom even the $75 surcharge is a substantial financial hardship. And I've also seen it not only in the courtroom, but for traffic tickets. A speeding ticket, which has a fine amount of $50, but with a surcharge of $75, plus a law library fee or whatever else gets added onto it, they got a $128 ticket to pay, most of which are surcharges and not the underlying fine. And they go in to meet with a hearing officer or they go talk to a prosecutor, and the prosecutor says, well, I can reduce your fine to $25, which I'm willing to do, but I'm sorry, you still got to pay the $75 surcharge because the legislature has mandated that it's not waivable. So this amendment would give the judge the discretion under the appropriate circumstances on a showing of indigency or undue hardship on the defendant or the defendant's family to waive that $75 surcharge, and would also to reduce it or to waive it. So they could tailor it to the financial circumstances at hand. And they also may permit the defendant to perform community work service in lieu of that surcharge. Some people have more time than they have money and are willing to contribute that time to the community as part of the consequence, rather than having to make the the surcharge payment. Even though, as I reemphasize, this is not a fine, this is not part of the punishment for the crime. This was a revenue raising piece, purely and solely. And if I had my druthers, I would remove this altogether, but that would probably create more of a budget expenditure than would be politically possible right now. But I would at least like to give the judges the discretion to reduce it or waive it when the person in front of them is indigent or suffering financial hardship to themselves or to their family. So I ask for your support for this amendment.
Thank you, Senator Latz. Senator Limmer.
Thank you, Mr. Chairman. Senator Latz, I was informed that judges are finding ways how to do this already through their own discretion. Is that true?
Senator Latz.
Mr. Chairman, I have seen it both ways. I've seen judges that apologize profusely from the bench when they impose the fine, and because they see me in the room, sometimes they'll look my way or they make mention that the legislature is requiring this. There's nothing the judge can do about it. And I'm sorry, but I have to make you pay this, as they talk to the defendant they're sentencing. And I've had other judges, frankly, they go ahead and they waive it and no one fights it. I suppose there could be an argument to be made that there's a separation of powers issue here about whether or not this particular surcharge crosses a line into appropriate judicial discretion. But I don't know. We don't need to decide that. Some judges feel bound by it. I would say most judges are bound by it and impose it. And that's when it gets in front of a judge. But, you know, on a traffic citation, someone gets pulled over for a speeding ticket and they see the total amount they're supposed to pay. They may just decide to go ahead and pay it, even if it becomes a real hardship for them. And they never talk to a judge, they never talk to a prosecutor, they never talk to a hearing officer. And that actually is another piece of this this amendment. It mandates that a notice be included on the traffic ticket, telling them that, you know, if they have a financial hardship, they can talk to the payment center and find out what their options are.
Is this a transportation issue?
Senator Limmer?
Senator Latz, is this a transportation issue? Would this fall into Senator Newman's committee with traffic fees, fines?
Senator Latz?
Mr. Chairman, I don't believe that it would, because it's not a fine and it applies much more broadly than traffic cases. So it's under Chapter 357 of Minnesota statutes, applies to criminal and traffic offenders. So at best there'd be dual jurisdiction, but we also, there are a lot of criminal cases that are in Chapter 169 as well that are within our Judiciary Committee's jurisdiction, I believe.
Thank you,
Well,
Senator Latz.
There's one thing,
Senator Limmer?
there's one thing, Senator Latz, that you and I agree with. Someday I hope we can work together on getting rid of the surcharge altogether. But as you stated, it's very, very costly. Just for the moment, Mr. Turner, can you tell me what the surcharge is worth these days as far as total dollars, or some kind of estimate of what it's worth?
Mr.
Yes,
Turner?
Mr. Chairman, members, surcharge brings in about $30 million a year.
Ooh,
It would cost, to bring it down by $1, it would cost about $400,000 per dollar.
per dollar, and we start at 75.
Yeah.
Okay.
Mr.
Yeah,
Turner?
we'll have to wait for another day on that, Senator Latz. Mr. Chairman?
Is there a fiscal note or an estimated cost on this amendment?
Yes, Mr. Chairman and members, fiscal notes drawn to House File 306. It comes to approximately $1 million a year, $889,000 the first year, and $1.2 million each year after.
And I'm assuming, Mr. Chair, that we're dipping into the Department of Corrections pool again. Is that correct?
Mr. Turner?
Mr. Chairman, yes. Coming out of the base of Department of Corrections Institutions Division.
Thank you, Mr. Turner.
Mr. Chairman,
Senator Latz?
keep in mind that that $1 million is coming out of the pockets of people who, by definition in this amendment, are indigent already, or who are facing an undue financial hardship for themselves or their families. So it is robbing the poorest of the poor, the most financially stressed parts of our population.
Thank you, Senator Latz. With that, members, we'll take up the Latz motion on the A9 amendment.
Mr. Chairman, I'd like to know if Senator Limmer would consider this to be a friendly amendment, and will offer his support.
Senator Limmer?
Mr. Chairman, this is an interesting amendment. I'm very concerned about dipping into the Department of Corrections budget. So I'm going to have to say no to this amendment, Senator Latz.
Thank you, Senator Limmer. Senator Latz?
Mr. Chairman, I'm going to withdraw the amendment.
Senator Latz withdraws the A9 amendment. We're back to Senate File 970 as amended. Any further discussion on Senate File 970? All right.
Did we- Mr. Chairman,
Senator Limmer.
Mr. Chairman, apparently we're at the end of our discussion. I'd like to make one final motion, and that's to simply give Mr. Backus cleanup authority to make necessary technical and conforming changes to incorporate all of our amendments to the bill, and to also consider reorganization of the bill, such as separating and organizing articles to make it logically structured. And we do this often for our new members. We do this often and give that instruction to our council as they put the bill in its final presentation. And I make that a motion, Mr. Chair.
Thank you.
As an instruction to Senator or Mr. Backus.
Thank you, Senator Limmer. Let's take that up on both then. So on the Limmer motion, oh, Senator Kiffmeyer.
Yeah, Mr. Chair, I'd like to ask for a roll call. And
Mr. Chairman, Senator Kiffmeyer, this is just on the motion to give council
fine, no
authority
roll call.
to clean up. So I
No.
don't think a roll call would.
Mr. Backus does a
We
great job.
certainly can give it a roll call and put it in the journal to make sure we get Backus's authority on this. But I think right now we'll just do, we'll keep it out of the journal
Aye.
if we can. So if we can go back to it on the motion to give Mr. Backus the cleanup authority to make the necessary technical adjustments to Senate File 970 as amended. All in favor of that motion, please indicate by saying aye.
Aye.
All opposed? The motion passes. All right, we are back to the bill.
So, Mr. Chairman,
Senator Latz.
on the bill as a whole, as is not uncommon for judiciary public safety bills, in my personal judgment, the greatest challenge with this bill is not what's in it, but what's not in it. I can support on the merits almost everything in the bill. Had we had an opportunity to hear some of our budget related amendments as standalone bills, perhaps there would have been an opportunity for Chairman Limmer to seek a higher target to accommodate some of the goals and desires of the committee. Say, for example, the last amendment, the A9 amendment, that it's quite clear Senator Limmer and I agree on the desire to reduce it. But, we intentionally drafted these budget related amendments in a manner that would dip into funds already accounted for within the proposed budget and target. Even though Senate Rule 7.04 would allow us to fund beyond the target, we are not be constrained as a matter of Senate rules by the choice of the Senate majority to identify the target that we have. Had we and Chairman Limmer been able to identify another $5 million worth of excellent proposals that he felt ought to have been funded, he would have had more of a basis for asking for a higher target. I would note that $20 million out of the $90 million target is siphoned off immediately to go into the disaster contingency fund, which quite frankly, isn't really only judiciary or public safety or criminal law related fund. It's an emergency response fund. It helps clean up after forest fires and floods and tornadoes and stuff like that. But I'm a little bit at a loss to understand why our budget is competing with that money, because it's absolutely every other jurisdiction, every other need. Roads and bridges get destroyed in tornadoes. The environment gets damaged. Housing gets destroyed. Municipal infrastructure, sewage treatment plants get destroyed. I mean, every other subject area is helped by that. And frankly, I think that should have been taken, that should have been coming out of a different budget, maybe just its own section of the budget under the full finance committee, rather than being charged off against Judiciary's budget here. So I guess this is another difficulty with not having had full hearings on some of these budget or proposals with fiscal notes, is it ends up tying Senator Limmer's hand a bit behind his own back when going to his leadership and saying, this is how much money I think we need to be able to meet the needs and priorities, even of your caucus, without accounting for the needs and priorities of the minority caucus, which is still comparatively a slim minority, notwithstanding the disproportionate membership on the Judiciary Committee. I wish that we had had the opportunity to seek more funding. I think that, as Senator Limmer has indicated in his own comments when we first heard the budget, and in previous years as well, that when we get into conference committee, the target is going to end up being somewhere in between ours and the other body's target. And there will be more money available to do things. And I hope that perhaps, even though we weren't allowed by the majority to put some of these meritorious bills into this budget, because of the fact of where the money is coming from, or is proposed to come from in our amendments, that the chairman will give fair consideration to finding room for them in the final conference committee report, because some of these I know will be coming into conference committee, but not from the Senate. So I'm going to support the bill, despite my misgivings about some of the features of it and really what's not in the bill as well. Thank you, Mr. Chairman.
Thank you, Senator Latz. Senator Bingham.
Thank you, Mr. Chair. I'll keep my comments brief. I don't see really anything wrong with what's in the bill, as Senator Latz said, and he's accurate. It's what's not in the bill. I'm more concerned about the fact that I don't think this bill is meeting the moment of time. We have a lot of things going on out there that I think we could have addressed in this bill, and amendments that were brought forward today from murdered and missing Indigenous women to hate towards Asian American, Pacific Islander Americans. We have real issues going on with our fellow citizens that need to be addressed. And I'm very concerned that bipartisan amendments, and I think most of you have worked with me long enough to know that that's genuine, were rejected, and they will address real tried and true issues that are facing Minnesotans. We have to fix the use of force statute. It's a real deal. Somebody will be made an example of, and on an appeal, if that case is charged out, Mr. Chair, and we have a responsibility to law enforcement and to our community to fix that. And I'm genuinely want to do that, and I'm rejected every time I reach my hand out across the aisle. Same with doxing of law enforcement's addresses. We can't have them distracted. They need to be focused on protecting our communities, and that's rejected. So I think that we have made a little bit of progress, still a lot more to do. But it's been a long couple days here doing the committee stuff, but I hope in the future, and it would be my request and my intent that we have a separate policy bill and finance bill, so that we can have and members can have the courtesy and ability to put forth ideas that deserve a vetting and the opportunity to have a hearing. And, you know, I'm here to always work across the aisle with you guys to get meaningful progress done. And I hope that when this comes out of conference committee, that there are some meaningful projects that meet the test of time. There are some very good things in this bill, but again, it's what's not in the bill that I think speaks more.
Thank you, Senator Bingham. Senator Limmer, oh, sorry, Senator Pappas, and then we'll go to Senator Limmer.
Thank you, Mr. Chairman. I wasn't sure if you were seeing the raised hand icon again. Again, I don't see anything real obviously objectionable in the bill. It just is pretty limited. And I believe there's a real hunger in the public for serious criminal justice reform, the area of police accountability, of juvenile justice, and in sexual assault. And we took one tiny step in that direction. Minnesota used to be kind of a shining light many years ago, held up as a model in terms of what we've done in our criminal justice system. And I just feel like we've fallen farther and farther behind. And in the last 5 years, we're continuing to fall behind. I agree that we need to be hearing a lot more policy bills and having these discussions and working out agreements that with all the stakeholders. And I don't understand why we're not doing that. I mean, when you have stakeholder support on so many issues, and it takes time. We saw that 3.5 hours last night, even with all the stakeholders on board, it still took us that long to resolve a fairly small issue. But we need to be doing this. I mean, I think we should have interim hearings. I think we should be much more aggressive in the work that we do. I think that Minnesotans deserve no less. So thank you, Mr. Chairman and Senator Limmer. I will be supporting the bill, but I'm not real enthusiastic about it.
Thank you, Senator Pappas. And Senator Limmer, would you like to have a few final words on the bill?
Thank you, Mr. Chairman. First, I would like to ask Mr. Turner, just a technical question. Do we need to adopt the spreadsheet?
Mr. Chairman, members, that's been the practice in the past.
And do we identify the spreadsheet by a date and time, or how do we do that? Could you give me instruction?
Mr. Turner?
Yes. Spreadsheet would be the judiciary budget fiscal year 22-23. Sorry, I've got to get. Fiscal year 22-23, Chairman Rec, dated 4/5/2021, time-stamped 3:03 p.m.
Mr. Chair,
Mr. Backus.
I'm sorry to interject, but we do commonly do the spreadsheet, and I guess there's nothing wrong with it. One thing to point out, though, that I believe the spreadsheet is that timestamp spreadsheet is technically incorrect now because of the amendments that the committee drafted. So you might want to at least indicate that it's
as amended. That
spreadsheet as amended by the amendments earlier today that Mr. Turner will put together.
Right. Mr. Chair, I'm going to try with a motion. I move that the spreadsheet as described by Mr. Turner and with the amendments that were adopted today, be recommended to pass. And it would be an accompaniment to the bill.
Thank you, Senator Limmer. So on the Senator Limmer motion, any discussion? Seeing none, if members would please turn their cameras on and their microphones on. All those in favor of the Senator Limmer motion, please indicate by saying aye.
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 Opposed? Motion passes. Senator Limmer.
Thank you, Mr. Chair. Before I conclude with the motion, I'd like to thank our staff. We have very good staff. The nonpartisan staff are second to none, and so are our respective staff with our respective caucuses. They've done a lot of work. Oftentimes, they're the power behind us, and they do an excellent job in a short amount of time, and sometimes with very fast opportunities to make decisions and give us advice. So I want to thank them for that. I believe maybe Senator Latz might want to make a comment as well, and I'll pause for that. Senator Latz.
Mr. Chairman, thank you. Yes, I wish to echo our deep appreciation for the staff to the committee and to the caucuses who focus on this committee. We are very fortunate, and the people of Minnesota are very fortunate to have an incredibly skilled set of public servants who dedicate their time, energy, skills, and intelligence to helping all of us do our work on this committee. And on behalf of our three Democrats on the committee, I can confidently say we deeply appreciate it and respect the work that they've done and thank them for it.
Thank you, Senator Latz.
With that, I just wanted to make one comment. Senator Latz had asked me if I had had any discussion with the person that gave me the target for this year. I have had very robust discussions with Senator Rosen regarding numerous years of budget as presented, budget targets, and this year was no exception. I too was confused or maybe bewildered about the $20 million in the SAFE Act as well. And nevertheless, there was no avail. I could not change that target in the chair's mind, finance chair's mind. But that's been an ongoing discussion and an ongoing struggle. But nevertheless, our budget is low. There's no question about that. And that low target has confined much of our discussion. And so just wanted to put that on the record. It's not as though we have not had our confrontations regarding that. But having said that, I want to thank everyone for the work that they did. It's difficult to sit for hours, but nevertheless, I want to thank you all. And even during the times when we dispute and have disagreement, it has always been with respect, and hopefully we still have maintained some collegiality in the process. And I want to thank you for that. But having said that, Mr. Chair, I move that Senate File 970 as amended be recommended to pass and move to the Finance Committee.
Thank you, Senator Limmer. On that motion, could members turn on their cameras and their microphones? All in favor of the Senator Limmer motion, please indicate by saying aye.
Aye.
All opposed? Motion passes. Thank you, members. Then Senate File 970, as amended, is on its way to the Finance Committee. Thank you very much. We are now adjourned. Have a good evening.
Thank you all.